the flag of our country, emblem of our Constitution, remember the principles for which they stand. The United States Supreme Court is now in session with the Honorable Chief Justice John Marshall will be presiding over the case of Dartmouth College versus William H. Woodward.
Good afternoon. Please state your names for the record.
Your Honor, I am Daniel Webster representing the plaintiff, the trustees of Dartmouth College. Your Honor, I am William H. Woodward, and I will be representing the defense.
The plaintiffs may begin with their opening arguments.
Thank you, Your Honor. Your Honor, the rule in law in question is, can the state legislature change the charter of a college? Other points for your consideration include, firstly, the charter issued was a private contract. Therefore, the contract is protected by the United States Constitution. As a result, the New Hampshire legislature impaired and or altered the contract when Dartmouth College was changed from a private institution to a public institution. My plea is that while the institution may possess some public characteristics, it is still a private enterprise whose trustees should not be deprived of their property, immunities, or privileges without due process of law. To meet our burden of proof, the prosecution will show a charter constitutes a contract in the fullest sense of the law because it includes all of the elements of a contract. Firstly, being competent parties, subject matter, mutual consideration, agreement from the parties, and mutual obligations. Your Honor, may I now approach for the defense?
You may approach.
Thank you. Your Honor, the defense argues that Dartmouth College charter is not a contract entitled to constitutional protection. Given the charter itself was issued by the English monarchy, the agreement is not entitled to constitutional protection. Your Honor, we maintain that the school's charter is a contract between King George III and the trustees based on Article 1, Section 10 of the United States Constitution. The corporate charter was deemed a contract between the private parties of King George III as well as the trustees of Dartmouth College. This mandate prohibits the states from passing any law which impairs the contractual obligations, thus prohibiting the legislature from altering the government method prescribed in the charter. Your Honor, the defense maintains that because the charter was issued by the English monarchy, it did not have any legal effect in the United States court system. Moreover, even if the charter did have a valid contract, it is not a contract within the meaning of Article 1, Section 10 of the United States Constitution. Rather, an amendable legislative act giving the New Hampshire legislature the right to change Dartmouth College from a private institution to a public one. Your Honor, the defense now rests. Your Honor, I implore you to revisit the unchecked legislative power of the state as it stands to jeopardize the future of all public colleges and/or private corporate investments. This case is not about whether or not Dartmouth College should be a private or state institution. It questions the protections of the Constitution's contract clause and assurances to which it protects private investments, private shareholders, and the founders of any private entity. If the New Hampshire statute is upheld, and colleges and holdings of any private corporation would be subject to the whims of politics, it is, sir, as I have said, a small college, and yet there are those who love it. We must preserve justice today, and the correct verdict is on you now to decide. Your Honor, the prosecution now rests. All rise.
A verdict has been reached. Dartmouth College versus Woodward. In a 5-1 decision, actions of the New Hampshire legislature were unconstitutional. The charter was considered to be a contract and could not be broken by the state. Of clear importance here, I must note, the Supreme Court reversed the decision of the state court. It guaranteed protection of contracts from government actions and defined a corporation as an artificial being. So it clearly defines that in that particular ruling of 5-1, the Supreme Court did reverse the decision of the state court, and that is final.
In a 5-1 margin, the court agreed with Dartmouth. Chief Justice John Marshall wrote the majority decision stating that the charter was in essence a contract between the king and the trustees. Although the United States was no longer a royal colony, the contract was still valid because the Constitution says that a state cannot pass laws which impair a contract. Historians believe the impact of the decision influenced business development, investments, and growth. This decision allowed businesses to feel more secure in their investments, knowing states could not impair charters or contracts. At the same time, businesses were given the opportunity to attract investors, hire employees, and promote national security. Ultimately, the ruling reinforced the idea of supremacy of the Constitution over the state and upheld the Contracts Clause.